Just a quick point of clarification here, because there's a lot of filings, they're using similar words. I just want to make sure that it's clear. I may have also added to the confusion with an earlier video that I took down as fast as I figured it out, and thanks to the people who pointed out. So there were 2 requests for extension filed by Lively yesterday. The first one was a request for an extension of time to serve something called requests for admission. Requests for admission are a discovery device that is available to the parties to serve on the other side to obtain discovery. So there are interrogatories, there's requests for production of documents, there's depositions, and then there's something called requests for admission. And essentially, there's statements that you're having the parties respond to the truth of those statements. So admit that it's true that you crossed the street at 5 p.m. Admit that it's true that the car that hit you was blue. Those kind of things. And the reason why those are important is that it kind of takes out issues of fact. It's stuff that the parties agree on, facts that the parties agree on, not ones that need to be in dispute once you get to a summary judgment. So usually it's sent out at the outset, but sometimes parties will wait until around the close of discovery, once there's been depositions, to ask for these admissions so that when they prepare their summary judgment motions, they have ready at hand what there are going to be disputes over, what facts there are going to be disputes over. And plaintiffs will want to have disputes of fact at this stage, because if a defendant files a motion for summary judgment, what they're going to try and achieve, their sole purpose in opposing a motion for summary judgment, is to show that there is an issue of fact. If there's anything that a defendant denies as a fact, they're going to try to use that in some way to show that there's an issue of fact. And if there's an issue in fact, a summary judgment motion fails, and then it goes to trial. That issue goes to trial. That fact gets to trial. So that's why we're seeing this now. They are asking for some clarification about whether or not the deadline is passed for that already with September 30th, or it was extended by the judge's changes to the deadlines for the depositions. They're asking for clarity, and they're saying the Wayfarer parties didn't agree to it, but Jones Works did, and Judd Wallace didn't say anything about it. They're wanting the court to weigh in to essentially clarify whether or not he had granted that extension in the past. So that is a completely separate thing, and that is the thing that the court has given Wayfarer until tomorrow 5 p.m. to respond to. So the hearing that's been set about the request for an extension in connection to the MJOP is completely separate from what the judge ordered earlier about allowing Wayfarer to have until tomorrow to respond to that request. So I don't know if he's going to address this in the Friday hearing as well with respect to the discovery. It may come up. Given how the hearings of this case have gone, a lot of issues have been touched on, depending on how the judge feels like talking about the given issue. So I don't know if they're going to talk about it, but that's not what the hearing is meant to be about. According to the order, it's to address the MJOP and the connected relief to that.